Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. This is also regarding professional ethics. Here, the heading is like this. So, the advocate should not be held criminally responsible, liable for improper advice. There are two advices, please remember. Illegal advice and improper advice. If it is illegal, definitely the lawyer also can be involved. So, an advocate was involved in a murder case as an abettor because he has instigated them. He told those people as to how escape from the clutches of the law by doing something, so which is irregular, I can't tell you, which is totally illegal. So if you give illegal advice, you may be involved. But improper, that means not proper. There are certain cases improper. Means suppose if you say that go for maintenance case, or go for divorce case, or go for restitution conjugal rights. So if it is, even though it is not proper, you may have told them that 4 or 5 optionals, channels, they can follow. But suppose without going for restitution of conjugal rights, if they say I want to directly the so-called divorce within 2 years, so this is improper advice. You have to ask them to wait, or in extraneous circumstances the court may consider 2 years period also. It may be waiving away the so-called 2 years period and grant them bail also. When the marriage has become, it has been irretrievably broken, yes, they can do it. Supreme Court directions are there. Here, the proper and improper. What is proper? Normally, ask them to wait for the cooling period, that is 2 years. What is improper? Come on, go ahead, because sometimes it may also be successful. Likewise, in property, so normally this case is relating to the bank standing counsel who has recommended for granting loan to the bank, so to the so-and-so customer. That fellow has become, that company actually has become non-functional, NPA, you may be knowing, non-functional, all these things. So non-performing assets. So when you say that so many properties are there, how they have gone? So you may be knowing, suppose if any reputed company takes over any SEZ, Special Economic Zone, what they will do? They will mortgage the same in the banks. They obtain so many loan and they will not repay. Ultimately, it will be debt letter, NPA, nothing will be there. Even though the land is costing about 1 lakh or 2 lakhs, they will actually expound it, or they will expound it up to such an extent, 10 lakhs or so, they will get loan. But when the field area comes, what happens? It is only 1 lakh, or it may be less than 250,000 also. This is the problem. Right? So this is what is called improper advice. So bank people, they don't depend only on the legal advice. Remember, while granting loan, they will look into so many other factors. Legal advice is only one point. So they cannot fix the legal advice or the advocate for giving the improper advice. Right? Justice Anand Kumar Mukherjee of West Bengal, Calcutta High Court, he quashed the proceedings against an advocate. So holding that the lawyer cannot be held criminally responsible, liable under 420 because he has given only improper legal advice. If it is illegal, definitely, and that too, in that case, there is no material to be saying against him under 420 and also 495. Actually, if you go to the facts of the case, so this advocate, being a panel advocate for a reputed bank, he has recommended loan to a company which has ultimately became actually it was due over 2.57 crores and became non-performing asset. So this is the no doubt. He said, the lawyer says, basing on the records available, basing on the market value, basing on the value at that particular time, yes, he has estimated this in so extent, and he said you can give loan. But the bank people also, they have to verify. Here, what the advocate will do is, he will verify whether the EC is proper or not, whether the registration was correct or not, whether the linked documents are tallying or not. That's all he can say. Basing on these things, yes, loan can be granted. Too much, to such extent, to so much of money, all these things, he is not bothered. That is the duty of the court, that is bank. Right? What happened is, since they became NPA, since the company became a non-performing asset, they have thrown the blame on the advocate. They have registered a case of 420 against the company, no doubt. At the same time, they have lugged in the advocate also. The Honorable High Court held that merely because lawyer's opinion was not acceptable, so the criminal prosecution cannot be initiated against him. Because, of course, he has also mentioned, in the absence of any tangible evidence that he was associated with other conspirators. ఈ లాయర్ గారు వాళ్ళతో కుమ్మక్కయ్యి ఏమీ లేకపోయినా ఉన్నదని చేసి ఎక్కువ రాస్తే ఎస్ డెఫినెట్లీ యాక్సెప్టబుల్. అక్కడ అంత పెద్ద ఎవిడెన్స్ లేదు. ఓన్లీ లాయర్ గారు ఏం చేశాడు, ఆయన రికార్డ్స్ చూసి ఎస్ యూ కెన్ గ్రాంట్ సమ్ లోన్ అని చెప్పచ్చు. అంతవరకు ఎంత లోన్ కూడా ఇతను రాయాల. కాబట్టి హౌ హీ ఈజ్ రెస్పాన్సిబుల్? సో please remember, the court wordings, it is beyond doubt that a lawyer owes an intermittent loyalty to his client. It is his responsibility to see to the interest of his client, definitely. So he has to look at the bank also. Merely because the opinion may not be acceptable, he cannot be held in criminal prosecution in the absence of tangible evidence. So therefore, he may be, no doubt, he may be liable for gross negligence or he may be liable for professional misconduct, is it not? But he cannot be held liable criminally. This is what the court said. So in this case, the typical point is, no doubt, he has given improper advice. Yes, he can be dealt with under professional misconduct, but not criminal case. So please remember, particularly the panel advocates to the banks, you can cite this case whenever necessary. Right? Thank you very much.